that yours? Sorry. Good afternoon, and may it please the court, I'm Jonathan Corbett. I'm the pro se appellant representing myself here in this case. There's a lot of public disagreement right now about how to fix the nation's gun laws, but this case, although it addresses gun licensing, doesn't address any of those issues. I'm asking for two things in this case. Number one, for the court to end a 100-year tradition of corruption in the NYPD licensing division.
See how that issue is before us.
Your Honor, the issue was thoroughly briefed. Essentially,
Well, I understand it's brief, but there's no factual record before us about that.
the factual record about whether there is corruption or how that affects my case.
Either.
Your Honor, I do believe that the briefing does go through a history of both the Sullivan Act, enacted in 1911, through present and repeated violations of the NYPD, ranging from mobsters in the 1910s to the Shamarim last year or 2 years ago. So this has been an issue that has pervaded the NYPD licensing division. It's beyond dispute, and it's currently the subject of a federal investigation. Two
Mr.
officers
Corbett, I
have
think
pled
what
guilty.
the hint is, why don't you go on to the issue specifically here where you were denied a full carry? Why don't we go to the merits of that?
Sure, absolutely. So the two issues that were relevant to the denial of my license were, number one, the proper cause requirement, and number two, refusal to answer three questions that were entirely irrelevant. And before addressing any of those, the more salient question is what the appropriate standard of review is to address those claims. New York courts have been fond of the saying that gun ownership is a privilege, not a right. But now in the wake of modern Supreme Court cases, we're talking about Heller and McDonald, the Supreme Court has been clear that it is a right, not a privilege. And that right has been held applicable to the states. So I think that...
You're a law student, correct?
Correct.
So I apologize for prematurely addressing you as counselor. But it's a right, but aren't there limits to all rights? Freedom of speech?
Absolutely.
And in this case, isn't there an appropriate limit using intermediate scrutiny?
There absolutely should be limits to gun ownership. I'm totally with you on that point, but the limits that are imposed by the NYPD are not tailored at all. So if we're going to look at this intermediate scrutiny, we can agree that the state has a substantial interest in protecting its citizens from gun violence.
How about also for preventing criminal use of firearms? Isn't that something that...
Absolutely. The interest is substantial. The problem is that they are also required to tailor their laws, their regulations, their restrictions to the problem they're trying to address. And in this case, what they've done is they've created a total ban for the average citizen, and that's just simply not tailoring.
It's not a total ban because some people get full carry, some people get limited licenses.
But not the average citizen. The NYPD literally considers proper cause to be a need greater than the average citizen. For the average citizen, for almost anyone sitting in this courtroom, even attorneys, your honors are accepted from this law.
I may have made that unclear by the premise to my question. If we're just talking even full carries, so just full carries, you agree, do you not, that not everyone is entitled to have a full carry?
Under current restrictions, that is the way the NYPD sees things.
Well, do you agree that's good law?
Absolutely not. Second Amendment rights are
What
not.
you're saying is everyone is entitled to a full carry.
Everyone who otherwise meets the restrictions that the Supreme Court has allowed, such as age and criminal history and citizenship, yes, should be entitled to a license so long as there's not a disqualifying reason. If someone has a mental illness that prevents them from doing it, a criminal conviction, that's another thing. But we're not talking about that. We're talking about just the ordinary law-abiding citizen. Okay. Thank you.
Thank you.
May it please the court, Alina Jerker on behalf of the city. Your Honors, there are two administrative decisions at issue here. One is the denial of Mr. Corbett's concealed carry full permit on the basis of his refusal to answer three of the questions, and the second is the FOIL. The preliminary, he appealed from a preliminary decision. It's since been mooted out by a subsequent.
Why don't you go just to the issue of the denial of his application?
The concealed carry.
Not the FOIL, just the substance.
So for the concealed carry, there's three questions on the application he refused to answer. Those three questions are, I mean, they've passed constitutional muster and been challenged before. The appellant has conflated the standard on an Article 78 with the constitutional question, and so said that any deference to the agency is inappropriate. That's not correct, because what the agency is doing is it's interpreting a regulatory scheme that's entrusted to it by the state legislature, which has been upheld on constitutional grounds. His objections to, and I just separate, there's two different bases for the denial. One is the refusal to answer those three questions. That is one that each of those three questions is germane to the question the NYPD is trying to answer, which is the scope of the background investigation it conducts. On the carry, this court need not reach that, first of all, because there's this independent basis to deny it. But on the carry, the Second Circuit in Kachowski addressed this very question and upheld the concealed carry restriction.
What about the
proper
argument
cause
made by the petitioner that in essence is a total ban, so under Heller, presumably would be unconstitutional?
Yeah, that's not what Heller says. What Heller says is that a total ban at home and hearth, there's a core Second Amendment right to have a handgun in the home. And then there is a peripheral right to have a handgun outside the home. There's a core right to have a handgun for self-defense in the home. What Mr. Corbett's application said is that he wants to have a handgun in order to exercise his civil rights fully in public. That is on the periphery of the Second Amendment. It's not a core Second Amendment right, which is the reasoning the Second Circuit used in Kachowski in upholding an identical challenge to the concealed carry proper cause requirement. Given the additional public safety risks posed by guns in public, the additional showing of a special need was upheld as substantially related to the compelling government interest at heart. For those reasons, if this, yes.
Mr. Corbett raised a question about what legitimate interests were served by asking the three questions which he refused to answer. Could you address what those are?
Yes, of course. The three questions he refused to answer, the first are about whether or not the applicant has ever used narcotics or opiates. Now, I think it's no question there's an opiate epidemic in this country. And so one of the questions that is the scope, and it's not a dispositive question. It's not saying if you've ever used a narcotic, lawfully or unlawfully, you can't have a handgun. The point is the NYPD uses that as a launching off point for its background investigation. It assesses if someone has a long history of using opiates, they might look into someone's drug history. Similarly, there's a question about the person being discharged from employment. Now, being discharged from one job several decades ago probably won't design the scope of the investigation, but if someone's been discharged from a number of jobs, let's say in the last 6 months, that might be a tell that they would use to look into whether the person's mental health or whether they've been accused of stealing, whether they've gone off and had a temper. Those are all qualifications those are all factors that might factor into the discussion about whether someone has the moral character necessary to have a handgun, which is what the ultimate test is. The final question is one about...
These are questions which go to good moral character.
Yes, these are all questions that are germane to the question of good moral character, and they're not dispositive. Under the regulations, the NYPD background investigators consider the frequency and the recency of any of the answers in both scoping the investigation and in weighing the options.
Thank you.
Thank you, Your Honors.
Your Honor, if we can take the first of those questions just to address how there's no tailoring, the opioid question. Whether or not you've been prescribed an opioid for a wisdom tooth removal or a tonsil remover and use them for 5 days is entirely irrelevant to one's good character. And the state
Well, I think
could...
as your adversary pointed out, this is not necessarily, that question and answer is not the be-all and end-all. It could very well be the basis for further investigation. Why isn't that relevant?
Right, because they could narrowly tailor it. They could say, have you used it for more than a week? Have you done it within the last 5 years? Any of these things would allow them to more narrowly tailor it, and they don't have any medical
At some point,
staff.
there's a follow-up in this process, isn't there?
There is a follow-up, but there is
So
no...
don't you think that might become the subject of the follow-up?
Correct, but I should not be required to delve deeply into my medical history in questions that are entirely very personal in order to exercise my Second Amendment rights. And I must correct my colleague that these three questions have not, to the best of my research as only a law student, have not ever been challenged as far as their constitutionality. This is an issue of first impression for this court, and I ask the court to ensure that the city narrowly tailors the questions, not unreasonably, but just something, a time frame, any kind of boundary whatsoever.
Thank you. Thank you
Thank you.
both. James River versus Mother Rock.